Hi, this is Dr. Stack here for my constitutional legal people, um, um, friends. How constitutional review quietly disappears. Doctrinal blindness explained. This I think is absolutely fascinating, from my point of view, from someone who's looking at constitutional law doctrine theory is it's incredible how it's applied, but particularly in time sensitive cases, we'll see is it applied or is it misapplied, or we won't make any we won't decide on a motive here. We'll leave the motive out of it. We'll just whether it was misapplied or applied, rather than the motive of the misapplication or otherwise. So we won't discuss that. So some constitutional cases are actually never decided. And what if a constitutional case can be lost without ever being decided? Not rejected, not upheld, just never reached. In this video, I want to explain a pattern that appears across constitutional democracies where entirely legitimate legal doctrines applied in sequence result in something far more serious: permanent constitutional non-review. What this is and is not: structure, not motive. We're not going to get into judicial intent or was the doctrine misapplied or not misapplied. We'll leave that out of it. We'll just talk about the structure. So we're not going to make a claim about bad faith or motivation or anything like that. I want to just factor that out of it. The quotient rule. I want to use the quotient rule here. The normal group factor out. It's about structure, about how doctrine operates over time, especially and particularly in election-related and state defendant cases, and how constitutional legality can quietly disappear without ever being examined. Procedural doctrine, necessary and powerful. So standard legal doctrines that are applied in these kind of cases are interim relief. Well, that's done all the time. Judicial restraint, non-justicability, particularly in these kind of cases, and mootness. Non-justicability now obviously was the first. So that was the first kind of ruling, if you like, or judgment. Sort of the first doctrine that was introduced or relied upon in a first case in this into constitutional actions. So constitutional courts rely on procedural doctrines to manage timing, uncertainty, and institutional boundaries. These doctrines are legitimate. They're orthodox. They're necessary, and when they all share a critical assumption that refusing to decide now does not mean refusing to decide ever. So they all share a critical assumption that refusing to decide now does not mean refusing to decide ever. So if we think of a time-sensitive case like election, you have the time before the election date, and then after the election. So you have that continuum there in election, presidential election. You could say the time the clock starts when the presidential order has been issued, and then you have the date of the end of the nomination period, and then you have whatever amount of time between that, usually fairly short, between that and the election date, and then post-election. So the first doctrine typically engaged in election-related litigation is interim relief, often framed as the balance of convenience. Formally, this decision is provisional. It does not address constitutional legality, but in time-sensitive cases, that assumption fails. Once an election or referendum occurs, courts are institutionally reluctant to disturb outcomes to which democratic legitimacy has attached. So a refusal described as temporary becomes, in effect, final. So interim relief, then if that's the doctrine that's used, that's a temporary. That's usually a temporary doctrine that actually becomes final in a case where so there's finality attached to that. So The second lock here is restraint without review. Abstention is not adjudication. After interim refusals, courts often invoke judicial restraint or non-justicability. These doctrines say only one thing: this court will not decide this issue now. They do not say the Constitution has been complied with. This is the complexity for litigants in person, say. The litigant in person wouldn't understand this necessarily. If they thought they had a perfectly valid case and it was declared non-justicable, the doctrine at that point was decided non-justicable. When you look at the theory now, it's non-justicable at this point. It doesn't mean that it's not non-justicable forever, because the person has, say, a right of appeal. But if the right of appeal is after the election date, isn't that confer some kind of finality? And then is that doctrine legitimately applied here? So there may not be judicial error here, or we're not attributing any bad faith here, but are we saying that the doctrine has been legitimately applied in a case like this, in a time-sensitive case? They do not say that the Constitution has been complied with, but here is the structural problem. In time-sensitive cases, these abstentions are rarely reviewed on appeal before the constitutional event is complete. A decision not to decide becomes functionally unreviewable, or may become functionally unreviewable. The pivot from not yet to too late. Before, premature; after, moot. Once the event has occurred, a third doctrine appears: mootness. Courts say there is no longer an effective remedy. That may be true, but it answers the wrong question. Mootness concerns remedy, not legality. Yet in practice, the absence of remedy is treated as if it resolves the constitutional issue itself. The system can move seamlessly from not yet appropriate to now academic. At no point is constitutional legality actually examined. The clever part: doctrinal substitution. Non-decision implied resolution. This is where the process becomes genuinely subtle. Earlier procedural abstentions, refusal to intervene, findings of restraint begin to be treated as if they carried substantive weight. And non-decision quietly substitutes for a constitutional answer. The substitution is never acknowledged. The language of procedure is preserved, but its limits are exceeded. Reframing. When the case becomes the problem. Personal grievance is not a doctrine. At this point, something important happens. The constitutional claim is reframed, not as unresolved, but as a personal grievance, a private complaint, or an abusive process. This is crucial. Personal grievance is not a recognised constitutional doctrine. It appears only constitutional review has been foreclosed. The issue is no longer legality. The issue becomes the litigant. Escalation and risk sensitivity. Higher constitutional risk is generally correlated with stronger reframing. What's striking is that this reframing is not random. Across constitutional democracies, the pattern appears risk-sensitive. The more institutionally sensitive the case, elections, democratic legitimacy, state power, the earlier adjudication is avoided and more forcibly reframing mechanisms are applied. In other words, the more dangerous the constitutional question, the less visible the doctrine becomes. Costs. Enforcement of silence. Costs follow reframing. Once a constitutional claim has been reframed as unreasonable persistence, costs often follow. Not because the claim was frivolous, no court ever said that, but because continuing to seek adjudication is treated as improper once silence has been normalised. Costs becomes disciplinary. Constitutional silence is not just produced, it is enforced. Why this pattern is hard to see? Well, very hard to see. Each step is orthodox. The sequence is not. Every step in this process is doctrinally orthodox when viewed in isolation or alone. That's why the pattern is so effective and so difficult to perceive. What fails is not doctrine, but doctrinal coordination across time. That is the blind spot. Why naming it matters. Stability is not legality. Naming this blind spot is not an attack on courts. It doesn't require undoing past outcomes or abandoning restraint. It simply restores clarity. Refusal of interim relief can foreclose review. Non-justicability is procedural, not substantive. Mootness cannot substitute for legality. Reframing is not adjudication. That distinction strengthens constitutional legitimacy. It doesn't weaken it. Closing. Constitutional shutdown does not announce itself. Constitutional shutdown doesn't announce itself. It happens quietly, through doctrine doing exactly what it was designed to do, just not all at once. Making the blind spot visible is not disruption. It is constitutional maintenance. So that's the argument that's often invisible to many litigants in person, but it's pretty clear to me now, and that's the basis of a recent paper, and it looks at how constitutional challenges are shut down in constitutional democracies, and the strategies and the doctrines used to shut them down, and it raises major questions about it's not just the ethics of not adjudicating these constitutional blind spots, but on not recognising. It's not just that. It's actually the constitutionality of not recognising constitutional blind spots. So there's, in my opinion, it is a constitutional question. If a constitutional blind spot is identified, it has to be recognised and it has to be dealt with as part of constitutional law. So that's what I would that's my take on what constitutional law should be about. That if there is a constitutional blind spot, then constitutional law is absolutely required to deal with that constitutional blind spot, because not doing so undermines democracy, separation of powers, and accountability, all of that, and particularly and dealing with it and recognise it does the opposite. It strengthens it strengthens the constitution. In all these constitutional blind spots where they're visible or they're found, the designers of the constitution presumably did not envisage these blind spots. They didn't write the constitution, assuming these blind spots. I doubt it. I very much doubt it. When constitutions, well, particularly when the Irish Constitution was written, I doubt if anybody spotted, there could be a blind spot in Article 12. I very much doubt it. So the framers of the Constitution would require the people who are tasked with minding the Constitution or guarding the Constitution to certainly not recognising those constitutional blind spots would be absolutely critical to preserve the integrity of the Constitution itself and the original framers of the Constitution. So that's my contribution to Irish constitutional law.